You may not like what President Trump said to the Georgia Secretary of State about finding 11,000 votes to turn the Georgia election over to him instead of to President-elect Biden. You may not like it, but what he did was not a crime. And what others, including Carl Bernstein, are saying that it was a crime worse than Watergate. They're just dead wrong, and you'll hear why. Also, it should not be a crime for Julian Assange to report material that was sent to him, even if the material was stolen by others. You'll hear why free speech should prevail over these attempts to weaponize the criminal justice system on the Dershow. Today on the Dershow, we're going to be talking about grave dangers to freedom of speech. No, I'm not talking about the cancel culture. We'll get back to that. There's plenty to talk about with regard to the cancel culture. But the two dangers I want to talk about today are more immediate and even graver. The first is the attempt to criminalize President Donald Trump's conversation with the Secretary of State of Georgia and turn an innocent political conversation into both a federal and a state crime. Let me start with the accusations. New York Times has a headline: Trump call to Georgia official might violate state and federal law. They quote various lawyers and criminal lawyers and even professors who say that the president's conversation may constitute a crime, the crime of knowingly and willfully deprives, defrauds, or attempts to deprive or defraud the residents of a state of a fair and impartial conducted election process. And I guess the worst offender, I'm not surprised, is Bernstein. Bernstein from Woodward and Bernstein, Carl Bernstein, who is turned into a complete one-sided zealot, political zealot. He says, here's the headline: Trump tapes worse than Watergate. And he actually, in the quote, he says it's far worse than Watergate. This was something far worse than what occurred in Watergate. Let's remember what occurred in Watergate. In Watergate, President Trump was caught on tape calling for the bribing of witnesses, for the destruction of evidence, and for other obvious crimes. And there was an impeachment process going after him for high crimes and misdemeanors, including bribery, one of the specified high crimes. I favored the impeachment of President Nixon. I think he did commit impeachable offenses, though CNN had me saying that a president can do anything, even if it's criminal. I took exactly the opposite point of view, and obviously will prove that in court. And one of the ways I will prove it is to show that I said that Richard Nixon could be impeached because he committed actual crimes. All right, you've heard it now. Bernstein, criminal lawyers, the New York Times, President Trump committed crimes or may have committed crimes when he had his conversation with the Secretary of State. So what did he say in the conversation? You can read it. You can actually listen to it. Several newspapers, I think the Washington Post, the New York Times, others, actually have the recording. It's close to an hour-long recording. I've listened to it. I've read the transcript very carefully. There is no crime on that transcript. Let's be very clear. Sure, he does use the word find, and he tells the Secretary of State that he should find 11,000 or so votes to turn the election against Biden and toward Trump. But what did he mean by find? You have to read it in context. What he says throughout the call is what he's been saying publicly and what he's been saying on Twitter for the last several months. What he says in the call is that there are many votes for him that were not counted. There were military votes. He says he wins the military, but the military votes all went for Biden. He said there were dead people votes. He said there were people from out of state that voted. And he said there were many ballots for him that were never counted. And so he says to the Secretary of State, find those votes. Don't make them up. Don't create them. Don't manufacture them. Find them. Don't invent them. Discover them. How is that a crime? President certainly has the right to say, I want you to look to see if there are votes for me that have not been counted or votes against me that should not have been counted and were counted. There's just nothing criminal about that. The president then says, if you don't do this, and if you allow this fraudulent election to go forward, you may be committing a crime and you may be responsible. I wish the president hadn't said that. I don't favor the criminalization of political differences under any circumstances, whether done by a Republican president or Democratic journalists. Criminal law should be specific, precise, and limited to people who have had the Hamlet moment to be or not to be a felon. You have to sit there or stand there and say to yourself, I am now crossing the line from lawful conduct to unlawful conduct. I am doing it knowingly, with malice aforethought, with premeditation, with intention. You can't just create crimes because you don't like what the person did. Even the statute that's being cited says knowingly and willfully. Those are the words of the statute. I challenge anybody to read and listen to the entire text of President Trump's speech and find anything that satisfies that statute. If we're prepared to expand statutes accordion-like simply to fit people who we don't like, we're in Stalin burial land. Remember, I've quoted this many times, the infamous statement by Lavrenti Beria, the notorious head of the Soviet KGB, who turns to Stalin and says, show me the man and I'll find you the crime. Well, Carl Bernstein, that's what you're doing. You don't like Donald Trump. You have seen the man, Donald Trump, and you will find the crime. Now, that's the use of find. That really is dangerous. Find me the crime. Make it up out of whole cloth. That's what Carl Bernstein's doing, and that's what some of these criminal lawyers, prosecutors, and others are doing when they say that clearly President Trump committed a crime. They are manufacturing a crime. They are inventing a crime. They're not discovering a crime. They're not finding something that already exists. They are trying to make something up. What President Trump said, on the other hand, was exactly the opposite. Find it. It's there. Do I agree with him? I don't know the facts. That's irrelevant. Whether he's right or wrong, whether politically you agree with him or disagree with him, that's not my issue. My issue as a constitutional lawyer and as a criminal lawyer is, did he commit a federal or state crime? By asking the Secretary of State to find, yes, find ballots that were cast for him that weren't counted, or ballots that were counted and shouldn't have been counted that were cast for Biden. Would he find some? Maybe not. He says there are only 2 people who voted when they were dead. The president says there are thousands. That's an empirical dispute, but it's not a crime. We have to be so careful what we make into crimes. And I think the worst offenders now used to be the McCarthyites who would make anything into a crime. Today, it's radical Democrats, even some moderate Democrats, who are prepared to manufacture, find, create crimes out of innocent political disagreement. The idea of weaponizing the criminal justice system to serve partisan political purposes is extremely dangerous. Look, I have confidence in incoming President Biden. I do not think he will try to manufacture a criminal case against outgoing President Donald Trump. I don't think he's going to do that. Also, I don't see how the state of Georgia could concoct a crime out of what he said there. In any event, the President of the United States would probably have immunity from state prosecution for acting within the scope of his authority. Now, you might argue he wasn't acting as president, he was acting as a candidate. That's a hard distinction to draw. But whether he was acting as a candidate or acting as a president, he simply didn't cross the line into crime. I would challenge Carl Bernstein to come on this show. I would challenge him to invite me on one of his shows and find me where in the federal criminal law there is a crime. You can't just make it up, Carl Bernstein. You're losing your credibility over Watergate. Watergate was easy. But to say this is worse than Watergate is to understate what happened at Watergate and to overstate what happened here. So, look, if you don't like what the president did, fine, attack him, criticize him, write op-eds about it, rail against him, but don't accuse him of crime. Because when you do that, you endanger the civil liberties of every American. You endanger the constitutional rights of every American. If prosecutors could concoct a crime out of this telephone conversation, then my friend Harvey Silverglade, whose brilliant book, 3 Felonies a Day, was written years ago, showing that the criminal law is so flexible you can charge anybody with anything, it proves the validity of what my friend Harvey Silverglade has brilliantly written many, many years ago. Let's not allow the criminal justice system to be turned into politicized partisan weapon to be used against political enemies, because today it's being used against President Trump. Tomorrow, it's going to be used against your candidate. And the day after tomorrow, it's going to be used against you, your spouse, your child, your relative, your friend, because the criminal law must be reserved for specific, clearly defined offenses that everybody knows where the line is. And when you cross that line, you know you've moved from innocence to guilt. That is not what's happening here. So let's end this conversation. Let's end this attempt to weaponize the criminal justice system, either against President Trump or by the current administration against their political enemies. It's wrong no matter who does it, and I will continue to stand up against either side, either political party, any newspaper that tries to weaponize the criminal law to seek partisan political purposes. Having said that, let's turn to the second issue that I want to talk about today, another great danger to freedom of speech, and that is the prosecution and the attempt to extradite Julian Assange. Here, of course, I have to first say that I am a consultant to the Julian Assange defense team. I first met Assange years ago when he was being investigated before he was confined. I met him in his lawyer's office in Britain. I have a photograph with him, and I have been in touch with him and his legal team over the years. To my mind, Julian Assange is simply the New York Times on steroids. It's a matter of degree. Julian Assange takes material that has been illegally obtained by others and publishes it. That's what the New York Times did in the cases that won them all those prizes. That's what the New York Times did when they printed the Pentagon Papers. That's what the New York Times did when they printed other material stolen from the United States and other governments. That's what newspapers do. They print material illegally obtained by others, and that's what Assange does. That's very different from Snowden. What Snowden did is he actually stole the material. What Manning did is she stole the material. What Daniel Ellsberg did is he stole the Pentagon Papers. Those people engaged in acts of civil disobedience. They committed crimes. It is appropriate under the First Amendment to prosecute those people. Ellsberg was not successfully prosecuted because of procedural errors and governmental misconduct, but he did commit a crime. The same thing is true with Manning and Snowden, who have been prosecuted. Assange is in a different situation. Now, the United States government says not only did he print material that was stolen, but he engaged in activities that actually encouraged or facilitated the stealing of the material. Don't you think the Times has done that too? Don't you think journalists from the New York Times and the Washington Post have gone to sources and said, hey, you got this material, it's great. Is there more? Can you get us additional material? Don't worry about it. We'll print it. We'll publish it. journalists can be very, very aggressive in seeking classified material that they want to publish, stolen material that they want to publish. And so I don't think Assange is very different from the New York Times, except in degree. And the First Amendment shouldn't be punishing, making criminal matters of degree. So this morning in London, there was a victory for Assange, but it was a modest victory. The trial court in the extradition proceeding refused to allow the United States to extradite Julian Assange to stand trial. But the court didn't do it on First Amendment and free speech grounds. In fact, it rejected those grounds. It said the United States had a plausible basis for seeking his extradition, despite the fact that it was a political case and it may have been a selective prosecution and it may have involved freedom of speech rights. I think the court was wrong about that. The court then refused to extradite on the ground that extradition would be deleterious to Assange's mental health and could actually drive him to suicide. Now, I think that's a very good precedent to establish, because I think many courts around the world will continue to extradite people, even if it poses dangers to their physical health and mental health. We know now that people have been extradited in some parts of the world, even though they face risks of COVID, catching it on the plane, people with pre-existing conditions, people who would be sent to American prisons which are infested with COVID. This case establishes a good precedent. What it says, essentially, is even if a person is extraditable on substantive grounds and might face a few years in prison, we're not going to sentence him to death, basically, by extraditing him if it would cause severe strain on his health, physical or mental, in this case mental, and in this case potential suicide. Now, the case is being appealed by the United States government. I don't know, because I haven't spoken to lawyers this morning yet, I don't know whether there'll be a cross appeal. I hope there will be a cross appeal. I hope both sides will appeal. I hope Assange will appeal the determination that substantively he's extraditable, notwithstanding the fact that he was a journalist simply exercising his First Amendment rights. I'd like to see that appeal lodged, and I'd like to see the appellate courts rule in Assange's favor on that ground. And the United States will appeal the mental health and suicide determination. So we're a long way from seeing a resolution of the Assange case. His lawyers today will be seeking his release on bail, and probably the conditions will be stringent because, as you know, and you'll remember, that he was previously on bail and he ran away to the embassy. He didn't run out of London. He just ran to the Ecuadorian, I think it was, embassy, where he stayed for a period of years. And then the proceedings against him in Sweden were dropped. And he left, but then he was arrested. And so he's been under some form of detention now for probably as many years as his sentence would be if he were tried and convicted in the United States. I think there are also efforts now to try to get him a pardon or commutation from President Trump. I don't know where that is going or whether that will succeed, but we're a long way from resolving the Assange matter. But the Assange matter does raise fundamental questions, both of freedom of speech and of equal protection of the laws. You can't have a different rule for the New York Times and WikiLeaks. New York Times may be more popular and influential, but under the First Amendment, I don't see any distinction between the New York Times, Washington Post, CNN on the one hand, and Assange's WikiLeaks on the other hand. The argument is that Assange printed the names of or gave printed information which could have led to the identity of spies. That, too, is a matter of degree. Probably the Times has done the same thing. They don't print the names of people, but they print information that, at least according to some lawyers, could endanger the United States. When the Pentagon Papers case was argued, I remember it was the former dean of the Harvard Law School, Erwin Griswold, who argued the case. And he argued on behalf of the United States government that printing the Pentagon Papers would endanger the lives of Americans. And the Supreme Court basically rejected that argument, and the proof was in the pudding. It did not endanger the lives of Americans. In fact, it contributed a great deal to helping end the Vietnam War. So, you never know when you publish material whether it will do good, bad, or a little bit of both. Usually it's a little bit of both. And that's why, under our Constitution, we err. We err on the side of protecting free speech. We should err on the side of protecting free speech we like. That's easy. But we should also err on the side of protecting free speech we don't like. So if you don't like what President Trump said on his call, you should still defend his right to express those views on a phone call. You should still defend the right of Assange, even if you don't like him. And there are things he's done that I don't like. I was a Hillary Clinton supporter, and he revealed information that hurt Hillary Clinton's campaign. So I don't like some of the things he did. I don't like some of the things the New York Times does. I don't like some of the things other media do. You probably don't like some of the things I say. That's not a basis for criminalizing free speech. So let's recognize that today was not a good day for freedom of speech, with efforts to try to criminalize President Trump's free speech and a court decision in England saying it was legitimate on the merits to extradite somebody like Assange who published material that was stolen by other people, although the court did refuse to extradite him. On balance, not a good day for freedom of speech. But when you listen to the Dershow, it's always a good day for freedom of speech because you'll hear freedom of speech expressed on this show. There will be no censorship. There will be no attempt to limit free speech to those that I agree with. Free speech is for thee as well as for me, and we must always remember that, or we will lose the most precious right we have under our Constitution, the right to criticize government, the right to criticize political enemies, the right to report information that the government doesn't want to see reported. Those are core elements of our freedom of speech, and freedom of speech is the bedrock of democracy. So now let's turn to your freedom of speech and your ability to criticize me with no constraints as we take today's phone calls. Our first call today is from Samuel in New Jersey.
In a Twitter conversation, someone said the following: it's the plaintiff's burden to allege facts suggesting Twitter made a knowingly false factual claim, or at least a false factual claim that believed probably wasn't true. This is in reference to the laptop repair person with the Hunter Biden laptop who's now suing Twitter. And so they're saying he cannot get discovery because he needs to first allege the facts, and just stating that Twitter defamed him and they did it maliciously, with he won't get discovery on that. I'm saying that since what they're alleging is that there was either that he hacked or that there was Russian hackers of some sort or something like that, and there's zero stitch of evidence for that, and there's other plausible reasons that it was more of a political partisan purpose, that's why they defamed him and called him a hacker, with zero evidence, that might be enough to get him discovery. Who is correct in this question? Thanks.
Thanks for your call. I think you're correct. If you allege in a lawsuit sufficient allegations, plausible allegations, they don't have to be true, they don't have to be believed at this point in time, but if you allege plausible allegations of defamation under the law, you should be able to prevail on the other side's motion to dismiss. And once you prevail on a motion to dismiss, which looks only at the face of the complaint, then you get discovery. So I think it sounds to me, on the basis of what you've said, that discovery should go forward. Our next call is from Italy. Max.
Hello, Professor. This is Max from Italy. Just had a question on a hypothetical. Biden gets sworn in on the 20th of January, and these court cases keep going forward. And then in a year, 2 years, whatever it is, evidence comes out that there was indeed fraud that would have changed the outcome of the election. Biden and Harris did not know anything about it. So what happens in that case? Just curious. And quick question. Is it true that you said that Ted Cruz was one of the smartest students you ever had? Thank you.
Thanks. First to Ted Cruz, he was one of the smartest students I ever had. I'll say that over and over again. He was also one of the most valuable students I ever had because he always presented contrary views in the classroom, and I didn't have to be the devil's advocate. So, I don't agree, still don't agree with many things that Ted Cruz has said, but he was and remains one of the smartest students I ever had. Now to the really intriguing first question that you asked. What happens if President Biden is sworn in, he serves for a year or two, and they discover massive fraud that he had nothing to do with? The answer is absolutely clear. No one knows. It's never happened. No one knows. We'd have to completely speculate as to what would happen. I suspect he'd be allowed to finish his term. He couldn't be impeached because he didn't do anything wrong. The closest analogy we may have is the election of John Quincy Adams over Andrew Jackson, and I think it was 1824. I may have my date wrong, but I think it was 1824. After John Quincy Adams was sworn in, having lost both the popular vote and the electoral vote, the Jackson partisans kept gathering more and more evidence of what they called the corrupt bargain. And I think many Americans felt that the election had been stolen from Andrew Jackson, but that didn't result in the removal of John Quincy Adams from being sitting president. But he lost overwhelmingly when Jackson ran against him again in, would be 1828, if my dates are correct. So I think the only remedy is political. And that is you continue to point it out, you argue, and then if you want to run for re-election, you run for re-election. But I can't imagine a sitting president being removed, especially if, as part of your hypothetical, he and the vice president had nothing to do with the corruption. The corruption was done without their knowledge or without their complicity. So I'm fairly confident that would be the result, but no one knows for sure. Our next call is from Canada. Jeremy?
Hello, Professor Dershowitz. My name is Jeremy. I'm from Ottawa, Canada. And I just wanted to say thank you, first of all, for answering one of my previous calls where I brought some potential religious challenges to getting a vaccine. I thought you did an excellent job responding and give a very good response. I have another question, and I've been thinking about this recently because you've been talking about injustices in the American justice system. And being from Canada, we have a lot of similar issues. For example, one thing that people don't know is that our prosecution of Indigenous peoples results in having a lot more Indigenous people in jail for the same crimes as other groups of people. In fact, I believe it's as proportionately higher incarceration for Indigenous peoples than even African Americans in the United States. So I guess my question is, if you could point to one justice system around the world that you think that Canada and the United States should look to as kind of their role model in restoring justice and in making our justice system more equitable for everyone. If you could pick one justice system from around the world, what would it be and why? Anyways, thank you so much, and I love your show, and yeah, thank you.
That's a great question. As you point out, virtually every Western democracy treats its minorities differently when it comes to criminal justice. That's true not only in the United States, it's true in Canada, it's true in Australia, it's true in New Zealand, it's certainly true in France, it's probably true in England. If I had to pick one country, this is going to sound strange considering its history, but probably today's German system of criminal justice, which denies prosecutors the kind of broad discretion that most other systems have, may well be fairer than other systems in the world. So I think that would rank very high. I think the Israeli legal system would rank very high as well. Yes, there is imperfect justice when it comes to Arab citizens of Israel who under the basic laws have equal rights but aren't always treated with complete equality, or even Ethiopian Jews and years ago Sephardic Jews. Every country has its problems with minority populations for several reasons. First of all, poorer people generally have higher rates of crime. That's not always the case, but in many jurisdictions that is the case, and minority people tend to be poorer and do have higher crime rates, even holding constant the factors that might lead to discrimination. But those facts alone don't justify the disproportionate sentences that are often given to minorities. So I do think the German system, which has less discretion built into it, may be the fairest in terms of how it treats its minority population. But I'd be interested in hearing from people from other countries. I'm thrilled that 2 of the calls today came from foreign countries. I want more calls from foreign countries. And any of you who have knowledge of your country and whether it deals more fairly with minorities, indigenous people, people of color, I'd be very interested in hearing your points of view as well. So thanks for a great call. Our next call comes from Virginia. Joe.
Hi, Professor Dershowitz, or maybe I should call you Dr. Dershowitz. That's a funny controversy going around. This is Joe from Falls Church, Virginia. I have a question about anti-Semitism and have a theory about it. I wanted to know what you think. So my question is, what do you think the origins of it are? Why have people hated the Jews for basically forever? I mean, from the beginning of recorded history, people have been trying to take them out. And my theory is little to do with religion, but it has more to do with jealousy. Wherever the Jewish people go, they set up shop, and they are outrageously successful. Just whatever they do, you never hear about, poor, uneducated, living in poverty Jews. They're just successful wherever they go, and other people look at them and they're jealous. And throughout history, as long as they're not being attacked and enslaved physically, they just set up shop wherever they go and they're successful. And people look at them and they say, that's not fair. Who are these people that are just advancing and we're not? And I want to know if you think that, and I don't know of any other culture that's like that. Wherever they go throughout the history of the world, they just set up shop and they're great. So I want to know what you think, if that is a reason or the main reason for anti-Semitism, and if not, what are some of the other reasons for it? Thanks very much. Love the show.
A great question. First of all, please don't call me doctor. I have 15 honorary doctorates. I'll never get another one because of political correctness, identity politics, false accusation against me, my defense of President Trump, my support for Israel. I'll never get another honorary doctorate, but I have 15 of them, but I don't allow people to call me doctor. My wife, who has a real PhD, which she earned for very, very, very hard work, has the right to be called doctor, as does Jill Biden. So please call them doctor, but don't call me doctor. You say Jews are successful wherever they go. You've never been to Brooklyn. You've never been to the neighborhoods I grew up in. There are poverty-stricken Jews. In Miami, Florida, for years, the elderly Jews, some of them were eating pet food. They were so poor. So there are poor Jews in many, many parts of the world, including in Israel. And that's why a lot of us contribute to helping not only poor Jews, but poor people around the world. But you're absolutely right. Jews are disproportionately successful. That is, a small number of Jews are disproportionately successful. Yes, they have important roles in the media. Yes, they help develop a lot of the social media. Yes, they are very prominent in the legal profession, in the medical profession. And I think you have a point. I think some of the anti-Semitism grows out of jealousy. Look, it originates even before the advent of Christianity. In the book of Esther, they talk about a certain people who are disloyal. In the book of Exodus in the Bible, they say there arose a king who remembered not Joseph and enslaved the Jewish people. But with the advent of Christianity, anti-Semitism became part of a theology. The notion that the Jews killed Jesus, Some people say Jesus was a Palestinian. That's so absurd. There wasn't such a country as Palestine until more than a century after Jesus died. Jesus was a Jew who lived in Israel. He lived in Judea. He traveled in Samaria. The Good Samaritan is a reference to Samaria. He lived in the places that are today Israel. And he was a good Jew. He said, I come not to change the law, but to make it better. And, he lived at a time of many people wanting to improve the Jewish law. You might call him the first Reform rabbi, but he was certainly a Jew. But Paul and others who came slightly after him did introduce some elements of anti-Semitism into Christianity. Thankfully, that's over. The Catholic Church has rejected it. Most Protestant churches have rejected it. Martin Luther, the founder of the Lutheran Church, was a virulent anti-Semite. He basically foretold the Holocaust. He talked about putting Jews in camps and punishing them. So there are religious elements to anti-Semitism, but there are also other elements. I think German anti-Semitism and Central European anti-Semitism was less religious in nature, although it was justified by religion, and more ethnic and political and economic. So I think you have a good point, but you overstate it when you say that Jews are successful wherever they go. Yes, among the most successful people in any country that has Jews are Jews. But there are many Jews that are less than successful, and they're not successful as Jews. They're successful as individuals who happen to be Jewish. And so when people talk about a Jewish cabal or the Jews control the media, what? The Jews control the media? Much of the media, Sulzbergers own the New York Times. They come from a Jewish family. The New York Times has been one of the worst things that ever happened to the Jewish people. The New York Times opposed the creation of Israel. The New York Times was silent about the Holocaust. The New York Times today is virulently biased against Israel. So just because a Jewish family controls the New York Times, when you say the Jews control the media, that's anti-Semitism. So it's a complicated phenomenon, but your point of view about jealousy certainly plays an important role in the enduring history of anti-Semitism, which Felix Frankfurter, Justice Frankfurter, called the most enduring prejudice known to human beings. I love getting return calls. This is from Ruvain in New York.
Hi, Professor. This is Ruvain calling from Brooklyn, New York. I just saw the Aaron Sorkin movie, The Trial of the Chicago 7. I know you were involved in defending that. I'm wondering if you might discuss a bit your involvement in that case. And particularly, I wanted to know, we know that, movies are fiction to some extent, and I'd like to know if you can describe what's truth and what's fiction. What parts of the movie are dramatized and what parts are real. Thank you.
A great question. You should always watch recreations of trials with an assumption that much of it is fiction. Much of it is filled in by the writer. There are elements of truth to the trial. Judge Hoffman was a martinet. Abby Hoffman was a provocateur. Bill Kunstler got in trouble. I represented Bill Kunstler on appeal and helped win his appeal, in which all the charges of contempt were thrown out against him and sent back for a retrial, which never happened. So we achieved total victory. In the Chicago 7 case, it was both a political victory and a legal victory, and I'm proud to have played a role in it. I didn't love all of my clients, all of the Chicago 7. They were a mixed bag of people. I got into conflicts with Abby Hoffman. We have an exchange of letters in which I complain about his sometimes borderline anti-Semitism, though he was Jewish, but he talked very nasty ways about his Jewish lawyers and about Israel. But for the most part, it was a fairly accurate portrayal, much more accurate than the O.J. Simpson portrayal that was on television, which was totally just made up. It was based on Jeffrey Toobin's book, which was also filled with fiction rather than fact, and selectively omitted a great many things about the O.J. trial. For example, the sock, which was planted by the police that had the blood of both O.J. Simpson and the victim. And we proved beyond any doubt, and the jury believed, that that sock was planted by the police. But you won't find any reference to it in Toobin's book, because Toobin had a narrative. He had a point he wanted to make. That is, that Simpson was clearly guilty and that racial elements determined the outcome of the case. So he didn't want to talk about the science. And the same thing was true about the version of it on television. I think the Chicago 7 version, which I did watch, was somewhat more accurate, but don't take to the bank any particular part of it. You have to check it against the record. Look, that's what, trials make for great fiction. Many of the greatest works of literature are based in small part on real events. Crime and Punishment by Dostoevsky was based on a real event. And the Brothers Karamazov. Dostoevsky would read accounts in newspapers, and then he would elaborate on them. Some of the other great works of literature as well. So literature has his place. Trials are a very important part of literature because they're so evocative and controversial. But always bear in mind that what you see on the TV screen may be quite different from what actually occurred in the courtroom. So thank you all. What great calls today from really all over the world, from Brooklyn to Italy. And please keep them coming. You're the wits that completes the Dershow. And looking forward to more of your calls on the Dershow.